Good morning, everyone, and welcome back to our weekly webinar series. Today is our 85th episode, and we are taking up a very important topic, which and also is a very recent judgment pronounced during this week, but the judgment was available day before yesterday, and this is with respect to the constitutional validity of the provisions of IBC relating to personal guarantors. So over to Anil, sir.
Thank you, Ankit. So, as you know, we are continuing with AAA weekly webinar series, and this 85th episode, which is in continuation without any gap every week, and we are going to celebrate our 100th episode very soon. So, the judgment that we are going to talk about it was much awaited judgment. Most of the insolvency cases of personal guarantors were in fact stuck up in this because of this judgment. The citation of the judgment is Dilip v. Jiwrajka versus Union of India, and it is basically for upholding the some provisions like section 95 to section 100 of the IBC, which is specifically applicable to personal insolvency, the constitutional validity of this, and the petitions were filed all under Article 32. In total, there were 384 petitions. The resolution process of personal guarantors, in fact, started, and the stay was granted by Honorable Supreme Court. Total 384, and there are in fact many more where the insolvency could not be started because of this stay of the Supreme Court. Even the personal insolvency of Anil Ambani is also part of this 384 writ petitions. In fact, originally when it started, it was the State Bank of India filed this petition in early 2020. In that scenario, in fact, in case we just go a little back, in 2019, the Ministry of Corporate Affairs notified certain sections which would be effective. Although all those sections were already there in the code, but they notified, and they notified only specifically for individuals who have given personal guarantee to a corporate loan. That was challenged, and the Supreme Court gave a judgment in May 20, and that was the... therefore, this particular judgment of Honorable Supreme Court is very important. It is opening up various professional opportunities for the insolvency professionals, and also opening up the process of recovery by the creditors. Now, going forward, we need to understand that although this particular petition is basically challenging the section 95 to section 100 of IBC, however, this section 94 is also important. So I mentioned that section 94 also should be understood what exactly this section 94 is. So section 94 is application by debtor, although it was not challenged. So therefore, application by a creditor, which is under section 95 of the IBC, that section was challenged. And how the interim moratorium is granted, this was also challenged by the creditors, that there are many personal guarantor who are filing their section 94 applications just to defraud the creditors and just to keep the creditors away from enforcing SARFAESI action because of the interim moratorium. That was also challenged. And section 97 was challenged because the appointment of a resolution professional whenever the application is filed under section 95 or section 94, the resolution professional is immediately appointed without giving an opportunity to the personal guarantor, and without even verifying whether there was a debt, whether there was a default, and whether that default remained unpaid or not. So all the conditions of section 94 subsection 2, those were all not verified, and the application is filed and the RP is appointed. So the constitutional validity of this section was also challenged. Then, of course, section 98, like the replacement of a resolution profession, not much of arguments were found on this replacement of resolution applicant. Section 99 report. See, when the RP is appointed, the duty assigned to RP is to provide a report under section 99 of the IBC, where the RP has been given the task to understand the application, see the facts of the case, and recommend whether the application can be admitted or it should be rejected. Now, what are the bases? The bases are some kind of verification of facts, some kind of verification of debt, default, and also whether the default has been curated or it is still continuing. So these are the facts which has to be verified by the resolution professional appointed, probably in the very first meeting, very first hearing. So this was also challenged. Now, there were the challenging issues were like the RP is the resolution professional is asking the information which is not even relevant for verification of these facts. The RP has been given adjudicating powers under section 99, where it is the natural justice is not prevailing. The debtor is not party to this process. And the report, a copy of this report is not submitted to the debtor. And then finally, section 800, admission or rejection of an application for commencement of insolvency resolution process of the personal debtor. So these are all the sections. So I, in fact, have given the detailed analysis of the section, but it is not really required. Section 95 says that the creditors to initiate insolvency resolution process. Section 95 continues with the various documents which are supposed to be attached. Now, this interim moratorium, it is important that when an application is filed under section 94 or 95, an interim moratorium shall commence on the date of the application in relation to all the debts and shall cease to have effect on the date of admission. So when the application is admitted under section 100, then section 96 interim moratorium would actually be, that will be withdrawn, and the new moratorium that will be under section 100, that would start. Now, section 96 moratorium was also challenged, but then it was restricted only for the creditors. It was not for the personal guarantor. It was not for that individual that we can also call this debtor. So when I say debtor, it may be confusing. When I say individual, it may also be confusing. Therefore, in our conversation today, I would be using the name personal guarantor. When I say personal guarantor, that means debtor. That means that person, individual who has given guarantee to the corporate loan. So I would be saying personal guarantor in my conversation today. This interim moratorium was also challenged because it was one-sided. The personal guarantor was able to sell their properties, assets. However, the creditors were not able to take any action and to proceed against the collateral securities mortgaged to creditors in case the application is filed. Earlier, even the application was filed, and even just a filing evidence would be enough for taking the shelter of under this section 96 moratorium. However, in a recent judgment, it has been held by at least the diary number should be given. At least diary number should be given so that all the defects are cleared and the diary number is given. That would be considered as filing of the application. So 96, and then interim moratorium, then appointment of resolution professional. In the very first hearing, it is supposed to be, the law is originally made in such a manner that in the very first hearing, if the defects are clear, then the resolution professional will be appointing, and then of course those provisions which actually relates to much before when the IBBI started making panel of resolution professionals. So these provisions like the credentials of the resolution professional will be verified by the IBBI. Those provisions are infructuous now because the IBBI has already come out with a system of having a panel of approved and credible resolution insolvency professionals. So this process where the confirmation of the appointment, IBBI reference, and all this is not required now. So the appointment of resolution professional and is under section 97, and then replacement of resolution professional. I just want to highlight one thing, that the replacement option, the replacement powers have been given to the personal guarantor as well as to the creditor. Both can say that I want to replace the insolvency professional who has been appointed as RP in my case. However, there is no option given to the debtor or to the creditor. There is no option given to the debtor or the creditor for replacement of the resolution plan. The creditor somehow has an option of replacing a resolution professional only for that part where the repayment plan needs to be implemented in a period, and that period needs some more kind of verification of the business of the personal guarantor. In that case, the creditors have a choice to appoint another resolution professional for monitoring of implementation of the repayment plan. But before that, the creditors also do not have any power to replace a resolution professional. That is something which is unlike the CIRP. So this is a unique scenario here in the section 98. So the section 99 is the submission report by the resolution professional. It is very clear that section 99 says that the RP shall examine the application referred to in section 94 or 95 as the case may be within 10 days of his appointment, and will provide a report to the adjudicating authority recommending for the approval or rejection of the application. Now, what the resolution professional has to see, because the words used here in this section 99 is may require the debtor to prove repayment. And so the words used is the may require the debtor to prove the repayment, and also the verification words are used. Evidence of electronic transfer of the unpaid amount from the bank, evidence of the encashment of check, signed acknowledgement of the creditor. So these are the kind of duties which has been given to the RP while preparing a report under section 99. And this particular part was also challenged before Honorable Supreme Court by the petitioner, in fact, 384 petitioners. So the resolution professional shall examine the application and ascertain that the application satisfies the requirements set out in section 94 or 95. The applicant has provided information and given explanations sought by the resolution professional. Even this part was challenged, that the resolution professionals are asking information which is not even relevant to the application, which is not even mentioned in the application for the verification of the facts. So then after examination of the application, the RP may recommend acceptance or rejection. So this was then a report would be submitted, and the report would be submitted to the adjudicating authority, and the RP has to recommend reasons. RP has to also provide reasons for recommendation or rejection. The resolution professional shall give a copy of the report under subsection 7 to the debtor or the creditor as the case may be. Now, to the debtor or the creditor as the case may be, because see, like I feel that this it has to be given to both. I also feel, because see, when the next action will come, section 100, that is the admission or rejection of the application. In this particular hearings, the report of the RP would be a part of the discussion, so that the copy must be going to debtor as well as to the creditor. So these are the sections which are actually challenged. And then after this, the adjudicating authority will decide regarding all the 3 or 4 conditions for acceptance. One, that there is a debt, and then there is a default, and then the default is continuing and it has not been paid. The adjudicating authority has to adjudicate, and finally the insolvency resolution process of a personal guarantor would commence, and the duty of the second phase of the duty of the resolution professional will start. So these are the basic sections which were challenged by the petitioners before Honorable Supreme Court. Now, this again, in case we see the contentions of the writ petitioner in all this discussion, 65-page order, the Honorable Supreme Court has mentioned what kind of contentions were taken by the petitioners jointly. The Supreme Court has also said that we are not narrating in the order the facts of each case, because the basic issues that before us we are trying to address those issues only. We are not going by the facts of each case. Now, in this case, the contentions of the writ petitioners was that it was basically fundamentals of jurisdiction to entertain an application. So the very first application which is submitted by the debtor or the creditor, the question is, what is the jurisdiction? Like the debtor, personal guarantor can file an application under Section 94, and only to the creditors will actually be adversely impacted. Somebody may file an application even if there is no debt, even if there is no default, even if the default has already been cleared. By filing an application, the personal guarantor is protecting his assets. So the first particular the writ petition contentions was that the fundamental aspect is not adjudicated, how the RP can be appointed in the very first hearing. So that is whether the giving the debtor or a personal guarantor an opportunity to be heard. So that opportunity is not proposed. It is not provided in the law. Application is submitted. The adjudicating authority will appoint the RP for giving a report under Section 99, and the RP will start collating the facts and finding the facts and then preparing a report. Now, the jurisdiction of Section 94 or 95, it needs a debt, and it needs that the debt is continuing and it has not been paid. So the contentioner said that even this part has not been, this part is also not considered. It is not, the opportunity has not been granted to the debtor or the creditors. Immediately RP is appointed. So in this case, there is no requirement of hearing before the adjudicating authority prior to the appointment of the RP. So in case you see the present process is their application is filed under Section 94 or 95. 94 application is basically by the personal guarantor. 95 application is by the creditors or a number of creditors jointly. So these applications are filed, and without any provision for any hearing, the judicial application of mind has not been proposed in this case. Immediately appointment of RP for providing a report under Section 99. So this was the first objection. Then under Section 99, a copy of the RP report is not provided to the debtor and personal guarantor. Although when I see Section 99, subsection 7, it is mentioned there that the report will be provided. Report will be provided to the debtor or the creditor as the case may be. I feel it is just like as the case may be is not required. So the report must be given to the debtor or the creditor. But this is also one of the contention that the whatever RP has written in Section 99 report, there is no provision that the copy of the report would be provided to the personal guarantor. This is also one of the objections of the. Then we have then the adjudicating authority must satisfy itself at that stage of existence of a creditor-debtor relationship, which must be demonstrated to exist. So the petitioners said whether there is a creditor-debtor relationship, that has also not been established. Simply in an application, after verification of the errors, the RP is being appointed. So there is no application of judicial mind at this stage also. The entire jurisdiction in terms of the entertainment of an application under Part 3, because this Part 2 of the IBC pertains to the corporate insolvency resolution process. Part 3 of the Insolvency and Bankruptcy Code is providing the insolvency of individuals, including the personal guarantors. So in Part 3, even the jurisdiction is not seen and the RP is appointed. So the appointment of RP has a serious consequences for the debtor, because it may even it may impact the credit worthiness and the social impact on the debtor. These are all the contentions of the petitioners. In many documents, they further argued that in many documents, the lending document trigger a default when an insolvency notice is issued, as a consequence of which collateral or independent debt may become invocable by a lending agency. Now, we also have seen such documents, and some of the private or international banks, when they lend loan, they also have a clause that whenever there will be an insolvency application filed against your company, this loan will become payable. So that is also something which was argued against this automatic appointment of RP provisions. So broad, the arranging inquiries which are made by the RP, the debtor is excluded from accessing the remedies of an adjudicating nature. So it was also argued that the RP is making a lot of inquiries while making this report under Section 99, which is not even required as part of the application. So those powers are in fact very large, and then it should be avoided. So so there are two basically issues. One, the establishing a jurisdictional fact, whether it is a case of debt and default or not. And then is the inquiries by the resolution professional. So the civil consequences would follow upon the conduct of an inquiry under Section 99 by the RP. So these are the contentions. As a consequence, natural justice involving the adjudicatory body must be read into the provisions at that stage. Now, the petitioners also provided the court some eventuality. Now, the eventuality is that the IBC is an invasive in rem proceeding and is highly prejudicial against the respondent. The contentioner said that the IBC is actually invasive. You have appointed RP, who actually is invading into our private information. Before initiating proceedings for insolvency under IBC and the appointment of RP, at the minimum, before the RP takes any action, there must be a determination by the judicial body. In fact, if you see in the past 2 years, the court, the adjudicating authority had started giving notices to the debtors or the creditors before even appointment of RP, because of the stay by the Honorable Supreme Court, and also because of the arguments given before the Supreme Court, not because of the order, because the order has just come. However, most of the adjudicating authority benches, they started giving notices. So then, or they were giving long dates, or they were saying that we would take up the matter after the Supreme Court decision. So they are the contestants, and the following ought not to take place automatically after the filing of an application under Section 95 without judicial adjudication or intervention. So they were saying that automatic interim moratorium should not trigger without judicial adjudication or intervention. It should not become automatic simply by filing an application. Second, they were saying that the automatic appointment of an RP subject to worthiness. Worthiness means the credentials of the RP. That also should not be done. Next, the resolution professional seeking information from the grantor, that also should not be done. The resolution professional examining the information received and submitting a report, that also should not be done, because this is too early. The adjudication has not been done. The jurisdiction has not been established. RP is being appointed automatically. RP is seeking information from the debtor, and that too invading information, and the information RP is actually examining the information. So they were saying that the RP is actually been given some kind of authority, which is an adjudicating authority, adjudicating. And whereas the Supreme Court later clarified that it is not adjudication. So then the contentioner said that none of the above steps, once performed, is reversible. Once the RP is appointed, the social impact has already happened. The credibility impact already happened. These are not reversible. When finally the adjudicating authority might even say that this is not a fit case for starting insolvency resolution process, then whatever actions has been done till now, like the application, moratorium, appointment of RP, seeking information, and filing a report under Section 99, all this is not reversible, and some of the impact would be there in the market, credibility, social impact. So the power to seek information not only from the grantor but also from third parties. They were saying they actually provided some of the evidences that the RP is also seeking information from third parties, maybe from the creditors. So that is also something which is, it has not been seen that somebody else having no adjudication power can do that. The common law consistently provides natural justice unless explicitly prohibited by statute. And how the statute prohibits? The statute normally prohibits like reasons like national security. So these are not those serious issues where the natural justice should be stopped. These are the arguments made by the petitioners. Further, they started comparing. So this is one part of the argument. Now, the second part of the argument is that they started comparing the provisions of Section 7 or 9 or 10, provisions of CIRP, Corporate Insolvency Resolution Process, and the provisions of Section 97, 95, 96, 97. And they're saying that in the case of Section 7 and Section 9 applications, no adverse impact can be seen because till Section 7 or 9, there is no public information except for the hearing. That the hearing can be public information, otherwise there is no public information. So they started comparing Section 7, Section 9 with Section 95 and Section 96 and 97. Then coming to the Solicitor General of India represented Union of India in our case, and then the contentions of the respondent means how the government of India, Union of India, in fact, responded to their various objections. And those various objections, in fact, the Solicitor General of India represented Union of India before Honorable Supreme Court. The first argument by Union of India was that this IPC is a time-bound resolution of insolvency, constitutes the heart and soul of the provisions of the IPC. Then the Solicitor General of India argued that the Part 2 and Part 3 of the Code contains distinct provisions. In Part 2, it envisages the exclusion of the existing management from the affairs of the corporate debtor. In Part 2, in the CIRP process, the RP is appointed. The directors are out. They are excluded from the management decisions. They are excluded from the decision-making powers. RP is appointed and immediately it impacts the business. So therefore, there is a judicial application of mind before the very, very harsh actions as provided in Part 2 means CIRP that in fact was proposed. A drastic moratorium comes into place following an successful issue. In case the resolution plan is not approved, then the company goes into liquidation. So all this is irreversible. So therefore, in Section 7 and Section 9, it is very, very harsh. Appointment of RP is very harsh. In contrast, in Chapter 3, in the case of appointment of RP, in the case of personal guarantor, now let us see what is the impact. Like we have seen the impact, Section 7, Section 9, the RP is appointed, the management is out, all the employees will start reporting, all the assets and the business will come in the custody, all the bank accounts will be operated by the RP, all the statutory compliances will be done by the RP. So, however, in the case of Part 3, the personal guarantors, in the personal guarantor, see, first of all, it is what is the insolvency resolution process? The Solicitor General of India argued that it is only a repayment plan which has to be required. The repayment plan, the only thing is that there is a loan, there is a repayment, and the nature of repayment plan if there is a continuing default. So this is what is required. This is what is required in the process of personal guarantors insolvency. So there is no takeover of the business. There is no like excluding from the management of the debtor from the any no powers are diminished, and so there's no impact on the business, because in CIRP it directly affects the corporate debtor, preventing asset transfer, encumbering, alienating, disposing of. So see, it was for CIRP, it is very, very difficult once the process starts. However, in section 99, the RP aim to collect facts, not adjudicate them. The debtor has an opportunity to provide all necessary information to the RP only for seeking the recommendation whether to accept, whether to go for the insolvency or not to go for the insolvency. The information is to be provided to the RP. Thus, the RP has to ascertain whether the application has provided, in the application all the information is provided or not. RP is not adjudicating. It is only under section 100 when an order is being passed by the adjudicating authority. At that time, judicial mind is being applied, natural justice is being delivered, the notice to the other party is being given. So at that particular time when the insolvency resolution process starts, till now, there was nothing. The RP had no adjudicating power. RP was only collecting information. So even during the course of the process, which is followed by a resolution professional, the statute has indicated sufficient engagement for the debtor with the RP. Sufficient engagement with the RP is giving opportunity to the debtor, to the personal guarantor, to come and provide information. And also it is said that section 96, in fact, it is protecting the debtor. It is not against the debtor. It is not against the humans. It is protecting the debtor, that if someone is going and saying that I just want to go bankrupt, so that means that he should be heard, that he's going to go bankrupt, so his assets should not be pounced upon. So this is what is the like contentions of the Solicitor General of India. Then we also say the consistent with the timelines which are provided by the IBC. That's what is the contention, that we have to be consistent with the timelines. It would be inappropriate to read compliance with the principles of natural justice at a stage anterior to section 100, since it would dislocate the entire scheme of the IBC. The concept of natural justice is flexible in nature. It has to be tailored to the needs of a given situation. It was argued that if an adjudicating authority had to determine a threshold at the appointment stage, section 99 would be otiose. Parliament has placed a resolution professional before section 100, focusing on information gathering and not for adjudicating. Then the section 99(3) prohibits debtors from disputed debt validity when registered with information utility. That's of course later. And also it was argued by the Union of India that in section 99 subsection 6, the words like examine, ascertain, satisfy, these are used, and there is nothing like it is being used as adjudicating authority. Further, it is said that even the Bankruptcy Law Reforms Committee and the board regulation, it says that the role of the resolution professional is not that of an adjudicator, So the role of the resolution professional is entrusted with a duty to maintain confidentiality. That's what is the confidentiality, and they also have referred to the code of conduct, like, and on the next page we'll say. So after considering all these facts, in fact, the total judgment was divided into 3 parts. Part A, comparative analysis of Part 2 and Part 3 of the IBC. Part B, applicability of the principles of natural justice. And Part C, challenge to the constitutional validity. So these are the 3 divisions made. a comparison, as I said, the role of the resolution professional in corporate as opposed to the individual insolvency, impact of moratorium, and the role of the adjudicating authority. So the comparison, when they started giving comparison, section 6, 7, 8, 10, it was all compared with the part 3. And in part 3, it is only there is no similarity, because in section 7, 8, 9, 10, all this is the application and then giving an opportunity to the corporate debtor of being heard, then to adjudicate whether there is a debt, whether there is a default, and whether the default has actually continued, and also if there is any dispute in case of section 9 application. So these are the issues which has to be adjudicated by the adjudicating authority before a particular CIRP can be started. Now, Ankit, because till now, is there any questions? And we can actually, because now we are starting the comparison between part 2 and part 3, means CIRP and personal insolvency. If there are any questions, we can take up, or in case you want to add something, that you can also add.
So I think it's like something which is, when we read this judgment, we feel that yes, there was an issue, or rather, there was a real issue that was debated before the Supreme Court of India with respect to constitutional power, with respect to. So had the moratorium for personal guarantors also been the way it was for it is for CIRP cases, it would have been that harsh, then maybe the court would have said that, there should be an opportunity of being heard before this happens. But anyways, I think even within IBC, even the CIRP process, when financial creditors, take somebody to court, that the whole opportunity of being heard, where the other person is allowed to, come before the court, tell what is his story, kind of is what, is important there then. With respect to the questions, so I think the questions are more to do with the procedural impact or procedural part of personal insolvency, which I think we can take up another day. Because personal insolvency is something that many people might have read earlier, but they might not be, able to remember the exact process there.
So we will miss some
Yeah.
of the comparison part of it, and then we will actually see what exactly has been adjudicated by the Honorable Supreme Court and how it will impact the practical, how to in all the cases it will impact. So we will take up the questions, all questions today, as I would be not really comparing the provisions of part 2 and part 3. However, in the first part, we are only saying that this is the debt and default has to be adjudicated in that case. However, in this case, it is not supposed to be adjudicated. So in this analysis, the Honorable Supreme Court has further said that the fundamental aspects which needs to be noticed is that part 2 of the IBC on one hand and part 3 on the other deals with the distinct processes of the resolution of insolvencies. The former deals with the resolution of insolvencies of the corporate entities, whereas the later deals with the resolution of insolvency of individuals and partnership firms. And the IBC, this is then the section 97 is 94, 95 is compared with the section 16, like the appointment of an RP as on the date of commencement date. So whereas in part 3, the RP is appointed much before the insolvency commencement. So the distinct eventuality, the liquidation broadly, like this is also kind of part 2 also refers to liquidation, that in case a process is started and it actually will impact the company in case it is not resolved and the company will go to liquidation. However, in the case of personal insolvency, it is only a insolvency resolution process. The bankruptcy is totally a different process. It is not linked with insolvency resolution process. Then when the comparative analysis, while doing the comparative analysis, further Supreme Court actually said that the statute has used the expression examine the application, ascertain, and satisfy the requirement and recommend the acceptance or rejection of the application. The use of these expressions leaves an adjudicatory functions to arrive at binding conclusions on facts. The role of the RP is purely recommendatory in nature and cannot bind the creditor, the debtor, or the adjudicating authority. So the binding order will come only from the adjudicating authority and not from the RP. RP's role is only recommendatory. Primarily, it is only to save the time of the court, as the RP has been given additional duty in this case to verify the facts, to provide some evidences, seek information from the debtor, means personal guarantor, and recommend it to the court. So in normal CIRP case, in case there are 5 or 6 average hearings before a case is admitted to insolvency, in this case, that particular time will be spent by the RP and the debtor. So this is what probably I think. Now, the impact of moratorium under Section 14 and the impact of moratorium under Section 96 is a C difference. The moratorium under Section 96 is only for the protection of personal guarantor, means the debtor, whereas Section 14 is a much stronger moratorium. That is also if it triggers, if Section 96 triggers only on filing of application under Section 94 and 95, it actually for the protection of the debtor. So that's what is Section 14 and 96. Now the role of the adjudicating authority, again, it has actually been a lot of pages have been spent on the role of the adjudicating authority. Evidently, the clear difference between the CIRP and Part 2, under Part 2 and the insolvency resolution process of Part 3, the legislature has carefully calibrated the role of the RP, imposition of the moratorium, and stage at which the adjudicating authority steps in under Part 2 on one hand and Part 3 on the other hand. In Part 2, the adjudicating authority steps in at the very, very initial stage. In Part 3, the adjudicating authority steps in after the appointment of the RP, after the verification by the RP, submission of a report by the RP, then only the adjudicating authority steps in, and then only the insolvency resolution process of a personal guarantor can start, which will be the first binding order. All this before that is not something which can be considered as a binding order. This is based on an intelligible differentia between the nature of the insolvency resolution processes in the case of corporate debtor on one hand and individuals and partnership on the other hand. Again, the natural justice. The Honorable Supreme Court has further said that the well-settled principles of law that natural justice postulates two requirements. One, an opportunity of being heard to a person who is liable to be affected by an investigation, inquiry, proceeding, or action. So now later on the Supreme Court says that in this process, there is no investigation, there is no inquiry, there are no proceedings, and there is no action against the debtor. So therefore, the natural justice is not being compromised. Then is the nemo judice in causa sua, which means that the person should not be a judge in their own cause. So the RP in this particular case is not behaving like a judge. It is only a facilitator. It is only an administrator. It is only providing some kind of assistance to the court. Further, it is pertinent to analyze that following aspect, the role of the resolution professional as a facilitator to collate facts, role of the adjudicating authority. Now, the role of the resolution professional as a facilitator to collate facts, which actually Section 99 very clearly says that Section 94 information, Section 95 information, and it has to be seen by the RP and a report has to be provided by the RP. So even otherwise, the role of the RP, it is very clearly said in 𝐝𝐤𝐬𝐬𝐬𝐜𝐻 versus State of Uttar Pradesh, to support the submission that unless such an exercise is carried out, the debtor cannot be exposed to a wide-ranging inquiry by the RP under Section 99, accompanied by a duty to furnish information or an explanation as required by the RP. The bench rejected the said assertion. The said assertion means that wide-ranging inquiries. The RP cannot make wide-ranging inquiries while providing a report under Section 99. In Esser Steel also, the Honorable Supreme Court has said that the RP's role is non-adjudicatory. In Swiss Ribbon, the Supreme Court has already said that the RP functions are administrative, not adjudicatory. In the report of the Bankruptcy Law Reform Committee, which is dated 4th of November 2015, affirming that the RP's role is primarily administrative for information and documentation collation and verification of the creditor's claim under Section 95. Natural justice further is being elaborated by the Honorable Supreme Court in the order. The demand for information, lacking an opportunity for personal guarantor to be heard, raises, according to petitioners, concern about violating the right to privacy. We are of the considered view that the resolution professional operating under the regulatory oversight of the IBBI plays a vital role in effective functioning of the insolvency process and contributes significantly to its efficiency. It is said that Regulation 7, Sub-Regulation 2, Clause H of the Insolvency Professional Regulations, read with paragraph 21 of the first schedule, which is the Code of Conduct, it casts an obligation of the RP to ensure confidentiality of the all information related to insolvency professional. Whatever information has been acquired by the RP to prepare a report under Section 99, that has to be kept confidential, which is provided in Regulation 7 of the Insolvency Professional Regulation and schedule, which is first schedule to Insolvency Professional Regulation, which is titled as Code of Conduct. So in that, clause 21 also says that the RP will keep all this information as confidential. Role of the adjudicating authority does not blindly, because the adjudicating authority's role, it is basically the elucidation of the role has also been done by Honorable Supreme Court, that the authority does not blindly accept or dismiss applications based on solely on the RP's report. Instead, it conducts a fair process, giving the debtor a chance to present their case. The adjudicating authority makes it its decision by evaluating arguments supported by relevant evidences, conducting an independent assessment beyond relying solely on the RP's report to determine the outcome of the applications under Section 94 or 95. The bench further said that the jurisdictional question of the nature which have been suggested by the petitioner, namely on whether there is a subsisting debt or whether the relationship of a debtor and creditor subsist, would involve a decision on mixed question of law and the facts. The entire scheme of Section 99 and 100 implicates timelines which have been laid down by the Parliament. The entire process of implementing these timelines would be rendered nugatory if an adjudicatory role. Now, the petitioner here again argued has a broad authority to gather information, like the RP has broad authority to gather information under Section 99, subsection 4. However, it is essential to clarify the scope of Section 99, subsection 4 is introduced with the phrase, for the purpose of examining an application. That means it indicates that the information sought by the RP should pertain to this specific purpose. The authority to request information or explanation is linked to the nature of the application filed under Section 94 or 95. The opportunity to submit such representation aligns with the requirement of the fair hearing. Once a recommendation is made, it is not binding on the adjudicating authority. The authority would only decide after looking at the recommendations of the RP and affording full opportunity of being heard. So these are all the the constitutional validity, and all this finally continuously being discussed, how the final decisions have been taken by the Honorable Supreme Court. So the the judgment which actually comes from the Honorable Supreme Court, that is like this, that in case finally it comes like this. Just a minute. So no judicial adjudication is involved at this stage. No judicial adjudication is involved at the stages envisaged in section 95 to section 99. This is like the Supreme Court has finally held that the role of the RP is not adjudicatory, as no judicial adjudication has actually been done or is involved. Then is the resolution professional appointed under section 97 serves a facilitative role of the collating all the facts relevant to the examination of the application for the commencement of the insolvency resolution process, which has been preferred under section 94 or 95. The report to be submitted to the adjudicating authority is recommendatory in nature and on whether or accept or reject the application. The submission that a hearing should be conducted by the adjudicating authority for the purpose of determining jurisdictional facts at the stage when it appoints a RP under section 97, subsection 5 of the IBC is rejected. No such adjudicatory function is contemplated at that stage. To read in such a requirement at that stage would be to rewrite the statute, which is impermissible in the exercise of judicial review, Then coming to the resolution professional may exercise the powers vested under section 94, subsection 4 of the IBC for the purpose of examining the application for insolvency resolution and to seek information on matters relevant to the application in order to facilitate the submission of report recommending the acceptance or rejection. There is no violation of natural justice under section 95 to section 100 of the IBC, as the debtor is not deprived of an opportunity to participate in the process of the examination. No judicial determination takes place unless the adjudicating authority decides under section 100 whether to accept or reject a particular application. The adjudicating authority must observe the principle of natural justice when it exercises the jurisdiction under section 10 for the purpose of determining. For the purpose of interim moratorium, section 96 is to protect the debtor. So the provisions of section 95 to 100 are not unconstitutional, as they do not violate Article 14 and Article 21 of the Constitution. Now, coming to the practical issues, Ankit, what now we can see how we can actually try to see the impact of this judgment. So number one, from now onwards, whenever an application is filed under section 94 or 95, the registry will see the errors, and once the diary number is given, it will be listed for hearing, and in the first hearing, probably, the RP would be appointed with a simple responsibility to provide a report on under section 99. Whatever application has been filed, a copy of that report would be given to the RP. Now that RP will start the process, will seek some information which is mentioned in the application, because RP has to seek the information which is relevant for an order to be passed for commencement of insolvency resolution process. And that can be the information about the debt, the continuation of debt, the default, and the default has not been curated. All this information is required, and also the verification of documents which are attached with the application. With this, the report under section 99 would be made. It will be submitted to the NCLT and to the adjudicating authority, and the copy will be provided to the debtor. Now, next time in the hearing, the adjudicating authority will consider the report of the RP. The debtor will challenge the report or not challenge the report. That will depend upon the report itself. And the adjudicating authority will take a decision whether to commence the insolvency resolution process of personal guarantor or not. So, therefore, it is going to be a very, very quick Now, it is going to be very, very quick now. And most of the cases which were in fact pending, and those all will commence. However, somehow I feel a dampener into all this. I feel a dampener into all this because, see, what is proposed by IBBI now in the discussion paper, that the insolvency professionals, they would not be able to take up more than 10 assignments. And out of these 10 assignments, not more than 3 assignments would be having claims of more than 1,000 crores. Now, in most of these personal guarantors, and see, like earlier when the regulation was made, Regulation 7, and then the Code of Conduct clause, paragraph 23 of the Code of Conduct of the first schedule to the Insolvency Professionals Regulations, it was only for the assignment of a resolution professional. However, now the IBBI have proposed that the total number remains at 10. Total number remains at 10. The total numbers like exceeding 1,000 crore creditor remains at 3 only. However, the definition of assignment is now enlarged. Earlier, it was only the assignment of a resolution professional, but now it is now extended to the assignment of IRP, RP, liquidator, and the RP of the personal guarantor or the bankruptcy trustee of the personal guarantor. So therefore, any personal guarantor of a large company will have a claim of more than 1,000 crore. So 3 cases of insolvency of the personal guarantors will take away the capacity of an insolvency professional for larger cases. Any person who has more cases, some cases are already going on under liquidation, some cases of insolvency resolution process will come in. So the capacity of the insolvency professionals is now, to my understanding, is reduced by more than 50%, or rather 75% it has been reduced, because the most of the cases that started long back, they are still continuing in the liquidation. The liquidation applications are filed, dissolution applications are filed, but those applications are not disposed of. So my status as a liquidator is continuing. Therefore, it is not really a very, very happy scenario for the insolvency professionals. Insolvency professionals are facing now, because they will not have the capacity to take a new case. Anyone who has taken in personal guarantors cases, they would actually lose a substantial capacity to take up the cases of RP or the liquidator. And now I think we can seek some questions, Ankit.
So, question from Ashok Ji. Ashok Ji is asking that now that government has added, or there's an article in the newspaper today that the government is adding 100 members to NCLT. Will it allow for early notification of individuals and partnership firms?
It looks like, because I think the Government of India is concerned about the bad debts in partnership firms and proprietorship firms, and the Government of India actually will think about it, because this law has to be extended, and everything else is considered to be, the IBBI is functioning very well. The resolution professionals are also functioning very well after a lot of changes by the IBBI. But I see, and the capacity of the NCLT is a very, very big step in case it will be done. In case this particular thought process is implemented, I think this will be another very big boon for the insolvency professionals.
Then we have a question that who pays to the resolution professional for appointment under Section 97?
Appointment under Section 97, in case we see, the appointment has been done by the RP. Anyone who has proposed, first of all, it is the duty of the proposer. Whosoever has proposed the name of the RP, it is his duty to pay the fee to the RP. In case no one has proposed and the IBBI has picked up the name from the panel, then the remuneration of the RP that will be decided by the creditors, and it will be paid out of the repayment plan. And in case it is not agreed by the creditors, then I believe the RP also might have a chance of resigning, because the fee has to be approved. The first is the proposer's responsibility. If the RP's name is picked up from the panel, then the creditors will fix the fee. And if the creditors are not fixing the fee, then it will be met out of the repayment plan. And if there is no repayment plan, like expected, I think the RP can take a decision of resigning. Any other question, Ankit? Your video is freezed.
Sorry, I broke off. So I believe there are other questions. The 10 restriction, we read it the other day. It was on insolvency matters, not on CRP alone, right?
I read it again, and it is on the. I read it again, and then I saw that it is now extended to all kind of assignments as an insolvency professionals. As an insolvency professional, like I also believe that even the AR assignment will be included.
Okay. So then, of course, so moratorium will, of course, right now till the amendments are made in the IBC, moratorium will start on filing the application, right? That will continue.
Moratorium already, it starts on filing the application. In the last week, we received we got a judgment from, I think, from a high court that filing means when the diary number is given. Earlier,
so that's what
the NCLT has given a decision that NCLT has given a decision filing means filing. That doesn't even mean a diary number. So now the High Court have corrected it that the filing means diary number is given. And the moratorium is only on filing.
Vimalji is asking a very relevant question for RP, is that when will the PG, for a PG assignment, when will the RP start getting any fee?
That depends on the contract between the proposer. Whosoever is proposing your name, it depends on the contract between you and the proposer.
So normally you would advise that some stage or some fee should be decided for the process before the matter is actually
when we are quoting, Ankit, when we are quoting any fee for the RP position of a personal guarantor, we are proposing the 3-stage fees. One stage is the before the RP is appointed by the adjudicating authority under section 100. Then the second is the from once it is appointed under section 100 for the next 6 months, and the other would be the if a repayment plan is approved by the committee and it is submitted to the adjudicating authority, so that period can be slightly different.
Right. So I believe we are overrunning on our time as well. There are other questions, but they are not with respect to this judgment per se. They are with respect to personal guarantee matters.
Yeah, I think we can see the personal guarantee issues.
So let me talk about this one. So basically, whether RP in case of PGE to CD can submit reply and file affidavit on behalf of the financial creditors and in his capacity as RP.
But that's not required.
It's not required.
The RP is like, there are the way of filing an application is that if the application is filed by the creditor and the also creditors are also proposing name of an RP, then the application also has to be signed by the RP before even filing. And see, once it is done, then the RP will be appointed for providing a report under section 99.
Yeah. Shivaji is saying, can the RP of the CARP consider the payment from the personal guarantors in the resolution plan? Yes, there is no limitation on that.
Sorry, what is the question?
RP of a corporate insolvency resolution process, can he consider the payment from the personal guarantor in a resolution plan? Yes, he can. There is no bar on that.
So consider payment means like now
maybe contribution.
NCLT has given a judgment that the resolution plan can also include the
This
personal
question is
guarantee.
question is different. This question is that the payment is coming in from the personal guarantor as a contribution towards resolving the debt of the CARP. So their personal guarantor can always, a resolution plan can always say that the personal guarantor will bring in money which will be paid to the creditors. There is no
So
bar on
any
that.
like that is only a source of funds. Otherwise,
Source
the
of funds it
creditors are
can be.
creditors, and the NCLT is only worried about what are you offering in a resolution plan, and you can source it from other people in case the COC agrees for it.
Mr. Soni is asking, please share a circular restricting number of assignments.
It is not a circular, it is the proposed discussion paper. It is a discussion paper which was released by the IBBA, and you all are presently asked to give comments on that.
So, but bank is asking for fee for the assignment. Vimalji is saying that bank is asking for fee for the assignment, but you should always propose a three-step fee, because in case you don't propose a three-step fee, then for the first stage you will not be working for any fee at all. That's the risk. So once we explain to the
Normally, the
bankers that
banks are giving fee starting from the order under section 100. They are not giving any, they are not proposing any fee for giving a report under section 99. However, in case in some of the cases, our partners have insisted and the banks have given the fee for the report also.
But what is your experience that one should ask for the fee for the report? Is that
One should ask
something
for
that
the one should ask for the report under section 99, a separate fee for that, and separate process fee per month for the insolvency resolution process, and that is acceptable also now.
then whether an RP appointed as IRP and becomes RP of the same assignment and appointed as a liquidator, whether it is presumed as three assignments or one assignment. So at any point in time, it will be
Yes, at any point of
as
time, it will
one,
be one assignment.
because you
IRP,
can't be IRP, RP, and liquidator at the same time for the same case.
what
You
we are
have to
saying,
be.
at one point of time, 10
Yeah.
assignments, and in addition to this, the 5 assignments has been given by IBBI in case you are a authorized partner and the case is assigned to IPE and you are an assigned partner. So there is basically now, there are 15 cases that a particular insolvency professional can do. 10 cases in his individual name, 5 cases as an authorized partner of an IPE. 10 cases includes all kinds of assignments, means the IRP, RP, liquidator, AR, RP of the personal guarantor and bankruptcy trustee. So these are all assignments under the IBC code wherever the requirement is insolvency professional. That is at number 10 for the individual name and 5 as an authorized partner. For an IPE, there is a limit of 15 assignments where the total claim is more than 100 crore. However, there is no upper limit for other assignments. So then IPE can have 100 assignments of where the total claims are less than 1,000 crores. However, the assignment has to be allocated to the partners, not more than 5 assignments to a partner.
Arun Kumarji is asking, how can RP know about personal assets of the debtor if he is not providing information, and how to validate his information from external sources? RP may be given authority to get information from income tax portal.
But
So
that
Arunji,
is only for the bankruptcy part. The RP's duty under this insolvency resolution process is not to take control and custody of the assets of the individual guarantor. The RP's duty is very, very limited in the first process of 6 months. Very
so in the
limited.
first process, yeah, that's there. And also, it is important to say that the objective of the first stage of the process is to identify if there is any insolvency at all. So in case one says that there are enough assets which are
No,
brought to the
I'm saying,
attention of the
Ankit,
court.
I'm not saying up to section 100. I'm saying once the insolvency resolution process is started for 6 months, the RP's duty is to see if there is a repayment plan comes. RP duty is to receive claims, interact with the debtor, ask him to
That's
submit
okay.
a
So
repayment plan.
Arun
First,
Kumar ji is not asking to take possession. He's saying, where do I get information with respect to
but it is not
assets of the.
required. It is not required. I'm saying it is not required. You are not mandated. You are not required to take this information. You are only asking for a repayment plan.
Right. So then, of course, we have, I think rest is taken care of. Do we see a surge in personal guarantee cases coming to NCLT? Maybe. Let's see what happens to the present
Yes,
cases first.
many
And I think
cases, but
looking at
then
the speed,
many
yes,
cases,
looking
but
at
then the fee level are going to increase because the personal guarantee cases are becoming part of your entitlement of 10 cases. So please don't give any fee which you can't afford, because in case somebody takes 10 cases of the insolvency, personal insolvency, that is the end of your capacity.
yeah. Um, how do you determine the quantum of debt in case of personal guarantee when the CRP liquidation is under process?
See, like the total guarantee, whatever personal guarantee, whenever the personal guarantee is given, the obligation of the personal guarantor is equivalent to the total debt of the company. Total debt of the company, the liability of the company as well as the personal guarantor is concurrent. The claim will come to the personal guarantor for the total amount, and the claim to the corporate debtor will also go as a total amount. However, in subsequently, in case there is anything which is paid to the creditor, they will file a revised claim and they will reduce it by that amount which is received by them.
Right. Will Form 2, will it be applicable for application under Section 94? Submission Regulation 4.2, Form 2, say an insolvency professional other than who has filed an application under Section 94. Rajesh Goelji's question.
I think for filing for the forms which are required to file an application, you have to go to the rules and not to the regulations.
Can RP give written consent to debtor before filing an application under Section 94?
RP has to give a written consent, and also the application has to be signed by the RP.
Yes. Sharing of report by RP debtor and creditor means based on the application filed by Section 94 or Section 95 and not to both.
Yeah, yes, in case it is an application under Section 94, then RP will give the report copy to the creditors. In case it is an application under Section 95, then it probably to both.
Vimalji is asking, please guide if 5 guarantors of one CD will be counted as 1 or 5 cases. They will be counted as 5
It counted as
cases.
5.
Yes. Is there an NCLAT order that multiple personal guarantors of same CD must have same RP? I don't see there is any such order.
There is no
It is
such
not
order.
important. Yeah, it is not. It is just
No,
done
I
this
think
way by
there was a
banks.
there was a proposal. I'm not sure whether that, because see, when this 18th
Hmm.
January 2023 uh, uh, public notice came for proposed amendment in IBC, there it was a proposal that the RP can be the same person.
Yeah, it can be, but it can be different
Then
also, right?
now it can be different also. Like then it was there like the maybe same person should be the RP for whosoever is the RP for the corporate data. That
So
was
there was something in the discussion paper or in the
yeah,
proposals.
yeah.
Okay. So then there is a question, what is the need for a two-step process, initial application admission and then after resolution plans, report admission of personal insolvency? Why is it a two-step process?
I think the
Why not
first
have
step
it?
is I think the intent of the parliament was to save the time of the adjudicating authority. So whatever time the adjudicating authority spends for determination of debt, determination of default, continuation of default, whether any payment has been made or not, all this responsibility has been given to the RP. Finally, the uh, proceedings under Section 100 will become a kind of summary proceedings and will save some time for the adjudicating authority.
Just
That
like a
seems
court
to be the intent.
administrator, it is like a court-appointed officer, court-appointed,
Yes.
assistant to, so that, one can kind of, court can get the information from the field.
Yes,
from
yes.
the RP. So the minimum fee of rupees 1 lakh, is it applicable to personal guarantor cases? No, there is no
No, that
personal
because
guarantor.
that fee is under the regulations which are only meant for CIRP.
So that is not applicable elsewhere. Whether assignments will also include chairman of monitoring committee? No, I don't think so.
I don't think so because see, for being a chairman of the monitoring committee, the qualification of an insolvency professional is not required.
Need to be an IP there. Whether the, yeah, so this is already taken care of. Can similar system of a two-stage process also be sought for admission in case of CRP? So
I
that,
think I
it also
already
speeds.
explained that the commencement of CIRP is a very, very harsh action. The existing management
Hmm.
goes out of power. All the assets and liabilities taken control by, because in this insolvency resolution process, there is no control and custody which comes to the RP. There is no the powers of the debtor which actually gets extinguished.
When there the two-step process is being talked about, the suggestion was that in case here we are asking the RP to go through the information or prepare a report, there again one can ask the court, NCLT can say that yes, this company has filed an application where it has claimed to be a creditor who is not being paid. So the RP can be appointed at a first stage process, and the RP can give a report with respect to the insolvency status of that company, whether the company's assets and liabilities are commensurate for the payment. So that was the suggestion, I guess, that came in. That
That
why
may be
not
for
have a
that may
three-step
be good
process
for
for CRP as
mediation.
well?
That may be good for mediation. Yes.
So that's it. I think we've taken care of all the questions.
Already, thank you very much. Thanks a lot. Because see, this was a huge attendance today, and that makes us happy. Thank you very much.
Thank you, everyone. Thank you. Pleasure.